My name is Melissa, and I work here at Prevalent in business development. And today we are joined by our very own compliance experts, Sophie Pothecary, who's one of our solutions engineers, and Thomas Humphreys, who is our content manager. They will explore how HIPAA impacts your third-party risk management program. So welcome to both of you.
Thank you. Hello, everyone.
Hello. And we do have Scott. I'm not sure if he's on yet, but Scott Lang will also be with us. Scott's our VP of product marketing, and he will dive into how we may be able to mature your TPRM program at the end of this session. So stay tuned for that 3 or 4 minute spiel. And, as a little bit of housekeeping, this webinar is being recorded, so you will get this along with the slideshow shortly after the webinar. And you're all muted, as you can see, so just use that Q&A box for those burning questions. And without further ado, I will let Sophie and Thomas get started. Go ahead, guys.
Thank you, Melissa. And yes, good morning, good afternoon, good evening, everyone. Welcome to this webinar, where we'll be talking through HIPAA, the HIPAA regulation, and how it impacts your TPRM program. I'm joined by Sophie. Sophie, would you like to give just a very short introduction to yourself?
Yes, thank you very much. And thanks for having me today. As has been alluded to, my name's Sophie Pothecary. I'm one of the solutions engineers here. And my focus today is really learn a lot from Thomas in terms of the HIPAA regulations, ask some of my own burning questions, and also provide some support.
Fantastic, thank you. And for those of you who are perhaps joining a webinar for the first time with us, my name is Thomas Humphreys. I'm the content manager. I'm responsible for developing assessments based on various regulations, standards, best practice frameworks. I used to be an auditor for the best part of 10 years before joining Prevalent and moving into the third-party risk space. As Melissa stated at the start, we always leave time for Q&A, and there should be a Q&A tab that you should see on the screen. So as we go through the presentation, just keep the questions flowing, and then we should have time at the end to answer as many as we can. So what are we doing today? So we're looking at HIPAA and the TPRM. I'm going to give a brief overview of the healthcare sector before looking at some of the key definitions and key requirements that HIPAA calls out, most notably around protected information and business associates. I'll be taking a look at both the security and the privacy rules or requirements before doing a deeper dive into some of the aspects that could lead to a third-party HIPAA violation. And then broadly speaking around some of the TPRM capabilities that only can address PHI risk, healthcare information risk, but also in terms of how you could again use HIPAA across your TPRM program and journey, particularly if this is the first time you're looking at this framework as well. So let's start by taking a broader look at generally what we're seeing around the sectors and the industry as a whole. I guess one of the obvious areas to note, similar to other industries, that across the whole, if you look at between 2022 and 2023, there have been an increase in many cyber attacks. More often than not, privacy and confidentiality is still listed as top risks and top risk areas. Both within top management, within law enforcement, regulatory bodies, and general standards bodies as well, and healthcare is no exception. We've seen that there has been a rise in healthcare sector risks specifically. This is more of a global level compared to 2022. On average, about $9 million is the cost of some of these, or some of the larger data breaches. And breaches against regulation, or as a result of some of the loss of information as a result of some of these threats. The WEF, the World Economic Forum, has publicly said these type of cyber attacks are on the rise. If you look at some of the ransomware, more notable ransomware-based threats, certainly MoveIt that came across in May and June, and is still having an impact. We're still finding more and more companies publicly stating they've been impacted. Well, there are key areas that are perhaps driving this. One of them is, of course, we're seeing more and more push towards digitization, digital transformation, use of more and more intelligent systems, applications, and solutions, which more often than not also means a greater and more in-depth supply chain. But on the same side of that, we're also seeing a lot of companies faced with legacy systems that are not only still used across many organizations, but legacy systems that are still housing, holding, or using sensitive data, such as healthcare information, healthcare data, and individuals' healthcare records. And of course, with the more legacy systems that still remain, one of the greatest risks being that these systems are no longer being patched, being serviced by the manufacturers and by the operating organizations, means to an increased level of impact should threats obviously target such systems. And of course, the large volumes of sensitive data. Certainly healthcare information is up there in terms of the level of sensitivity. And obviously, we're not just talking about tens of individuals or thousands, but more often than not, tens, if not hundreds of thousands of patients, of people involved in the healthcare system. And so we're looking at very, very large volumes of data, which of course is or can be very ripe for the likes of targeted ransomware threats and attacks, and similar attacks caused by hacking bodies and hacking groups, among other things. So there's a continued growth. We're seeing continued growth in the types of sophisticated attacks, type of cyber attacks, and it's clear that this is something that's not going away, certainly in the short term. I mentioned obviously with the advent of more and more technology and using more and more applications and systems, so the supply chain network naturally will grow as well. If we look generally across healthcare providers, there are a lot of different third parties we may be dealing with. Support services from the like of IT support, help desks, call centers, account centers, to consultancies and contractors working on site and remote, to those dealing with actual medical systems and devices and applications, so from pharma to contract manufacturers and maybe distribution vendors as well. And obviously what this does is it creates a large or an increased attack surface area for some of those attacks that I was just highlighting, so the likes of those ransomware attacks. And we've seen this in so many cases, not just in healthcare, but across many industries where an attack or a target attack on a particular application has then had a ripple or a rippling effect across an organization's wide supply chain. So the likes of the Kaseya, VSA, and SolarWinds, or the recent MoveIt vulnerabilities are good examples where it's then had a wider issue and spread out across an organization's supply base. This is where the likes of HIPAA could then come in to help tighten this and help to make sure that organizations are conducting and operating under a level of due diligence. And HIPAA, which is the Health Insurance Portability and Accountability Act, a US-focused act, really focuses on the lawful use and disclosure of health information or protected health information, PHI. And we'll see throughout today how HIPAA can be used from both a security and a privacy front to really sort of target and identify those risk areas and hopefully start to put in clear mitigation plans to minimize the chance of those threats, or at least the impact that those threats will have on the wider organization. So let's start to look at what HIPAA actually means and what it actually does. So I've mentioned security and privacy, and these are two separate rules. They call them the security rule and the privacy rule. And they're setting out clear objectives for how you establish and implement best practice controls, ultimately to secure health information or protected health information, PHI. As you can see from the right, I've put the trusted CIA. Anyone familiar with ISO standards and 27000 will be very familiar with this concept around protecting confidentiality, integrity, and availability of data. And this is an area that HIPAA carries through within its security ruling. So requiring organizations to ensure the confidentiality, integrity, and availability of healthcare information they're holding, making sure you're then protecting against reasonably anticipated threats and hazards. So we can think of the first part from a risk perspective. So developing a risk program to understand where are the risks based on what type, what volume, what complexity of healthcare information we're using, where that healthcare information is being stored, and then starting to think about, well, how can we protect against those threats and the hazards that we've identified? So security controls and privacy controls that can help limit the visibility or the access and tighten data security standards. Protecting against anticipated use and disclosure of PHI that's not permitted by the HIPAA privacy rule. And as we'll see throughout today, it's this use and disclosure of PHI which is so strong and repeats itself so many times within the privacy rule requirements. And the purpose here is making sure that we're putting obviously the right controls in place to protect that data, but also where we can limit any accidental or malicious wrongful disclosure of healthcare information, particularly that directly goes against the expectations of HIPAA. And then ensuring compliance of the HIPAA Security Rule, or HSR, by the wider workforce. So setting 4 key objectives or general requirements at the top of the security rule that sets the scene for how companies should address and approach HIPAA. So from that risk management and risk identification approach through to the concept of identifying appropriate controls, practices, policies, and processes to start to draw on what do we need to put in place at the right time. And what we'll do later on today is see how that works and impacts from a third-party perspective.
Thomas, just a couple of questions from myself. You touched on there some of the kind of similarities or some of the kind of terminology you've called out with the likes of an ISO, for example. But what are the differences that you see between really kind of HIPAA or healthcare industry frameworks versus the likes of a NIST or an ISO, for example?
So it's interesting. There's great questions. So we've got. So yes, I did mention ISO because CIA is a core fundamental part of the 27000 standard. So we need to remember, obviously, that HIPAA is sort of regulation. It sets regulation and requirement from an enforcement perspective. The likes of ISO and NIST are more standards, either national or international standards, but there is a lot of commonality between all three. So when we go through and take a look at some of the security rules of HIPAA, for example, they're covering very similar areas to ISO, for example, around technological controls, organizational controls, such as how you manage access of information and access of systems, security awareness and training of staff, for example, business continuity, contingency, and a lot of other key topics. So there's a lot of similarity between HIPAA and the likes of NIST and ISO. Obviously, each standard has its own unique points, and where ISO very much focuses on a wider governance context, NIST focuses on a very technical capability and actually goes to another level that the likes of HIPAA and to some degree ISO don't. And so there are some subtle differences, but at the same time, what this does mean is that organizations that are, say, already ISO certified or they've gone through attestations and compliance against NIST 853 for cybersecurity, it means that if they're approaching HIPAA for the first time, or they need to demonstrate or start to demonstrate how they comply, it will make it a lot easier because some of the practices identified through the likes of ISO and NIST, as they say, sort of mirror and in some ways go above what HIPAA expects as well.
That's really interesting. I think you mentioned there as well, you know, that obviously the similarities, but the difference between the regulations and the standards, etc. You've touched on there already as well, some of the other domains or risk domains that people typically are covering, when they're potentially approaching HIPAA. Do you see any benefit of embedding HIPAA alongside other tracking or TPRM programs that are looking at other risk domains, such as ESG, for example?
Yes. Potentially, yes. The key thing I think to always remember with HIPAA and like many of these regulations, they do obviously have a clear focus point. The key part here is looking at how organizations protect their health information, and as we'll see how that translates to the wider sort of third-party base. And it's important to note that the third-party base is quite evident and clear within this framework as well. It's not just looking at, say, a healthcare center or hospital or other medical centers or medical providers, but it's looking at that wider group of businesses or business associates, as they're called. So certainly if you have other frameworks already established, being able to map the requirements of, say, what HIPAA expects from a security and privacy perspective can make a lot of sense and can be used, as I say, to demonstrate wider sort of, not only compliance actually, but going beyond the expectation of HIPAA, which can always be a good thing, or I guess can only be a good thing, because of course you can always focus just on specifically what HIPAA is after. But if you can say, well, actually we've gone beyond that and it's a way of maturing how we handle our third parties or requirements and controls that we're using with our third party, then of course that's only a good thing.
Yeah, great. Well, thank you very much.
So I keep mentioning this term, protective health information, PHI. Like many regulations, HIPAA do sort of set out a series of terms or terminologies, and the one that does repeat itself quite frequently is this concept of health information. So what is it as defined by HIPAA? So they say individually identifiable health information that's held or transmitted by a covered entity or its business associate in any form or media, whether electronic, paper, or orally. Let's dig into a few more details around what this means. So firstly, individually identifiable. So as you can see on the left-hand side, there's a few sort of key bullets here that talk about what does individually identifiable information relate to. So any past, present, future, physical or mental health information of an individual, any provision of health care to that individual, and from a payments perspective as well, past, present or future payments for the provision of that health care to an individual. So what this means in practice is when HIPAA says we need you to abide by these security and privacy practices, implement these set of controls, or consider these controls in contracts, agreements, risk assessments, the focus is very much on all those organizations, including third parties, that hold or transmit any such information. And as you can see, in any form. So it doesn't have to be traditional paper copies. It could be in any form of media, electronic, paper and oral, as we can see. And one area that comes up quite consistently, particularly with regards to the privacy element of HIPAA, is disclosure, or what it calls use and disclosure of protected health information. And we can break this down into a few areas. So whether it's actual disclosure of information to the individual, so to the person whose information that data belongs to the HHS, Health and Human Services, who are the creators of the HIPAA framework and who set about in terms of enforcement actions and, as we'll see later on, violations. In terms of how information can be disclosed, whether it's for ongoing or future treatments, for payments of completed treatments, and for future and current operations and medical procedures as well. Notification and public interest is quite interesting. We can sort of see this also from a privacy aspect across other areas such as GDPR and other privacy regulations that are not industry or sector specific. But public interest refers to the likes of law enforcement, for example, and where there are cases perhaps that are involving highly sensitive individuals, such as children. And if there needs to be from a law enforcement, from a policing presence, and there needs to be visibility of that information, there are certain conditions where disclosure of such information is appropriate or allowed by an institution. But nevertheless, as we'll see, there's also very strict requirements as to when disclosure cannot be deemed appropriate and when violations, issues, penalties can occur and can be enforced by HHS and the wider sort of Office of Civil Rights as well. So HIPAA make it quite clear in terms of what they deem individually identifiable health information. And this is actually a key thing to point out, particularly when we're looking at which third party should we consider that would fall under HIPAA and that we should impress upon them HIPAA requirements or expectations. So before I go into some of these key terminologies, such as business associate, let's take a wider look at both the security and privacy rules. So as I mentioned, there's a lot of close link between the likes of HIPAA security requirements and other national and international standards such as ISO and NIST. And in fact, NIST have created standards specifically around how to deal with or how to implement HIPAA. I believe it's 800-66 that really focuses on the NIST viewpoint around HIPAA and HIPAA best practices. So as you can see here, there's three key safeguards that HIPAA call out: administrative, physical, and technical. And as we can see, there's a series of key security functions, sort of sub areas that touch on governance aspects. So managing of security, roles, responsibilities, training of staff, and more operational procedures, so the likes of incident, contingency, business continuity and disaster recovery, and business associate contracts, which is a key area we'll be coming on to shortly. And then physical and technical safeguards. So again, thinking from ISO and other notable frameworks. So physical security controls, facility access controls, thinking about the workstations, the desktop computers and other equipment that may be housing health information and controls that need to be considered to secure them. And then technical controls around data security, data access, data encryption, authentication of individuals, and auditing, logging and monitoring based controls as well. So again, following very similar processes to that of other notable security standards. From a privacy rule perspective, so the privacy measures set out how PHI data is and can be used, including governance, organizational requirements, and addressing change through transition. So in a similar vein, they've got three key subject areas, what they call use and disclosure, organizational and transitional elements, all key areas for an organization to consider. So from use and disclosure, which I partially covered, it includes a permitted use, what's allowed, what's required, what's prohibited, for example, the sale of health information, any minimum standards that are necessary when accessing and using health information, to some specific areas, for example, dealing with the health information of a deceased individual, for example, children as well, the use of confidential communications, and even down to the level of protecting disclosure by whistleblowers of an organization if they've spotted a potential or a serious violation. From an organizational aspect, this is where we come into a lot of core areas from a third-party perspective. So business associate contracts, which I'll touch on shortly, requirements for specific health plans, and for covered entities being the healthcare organizations, the hospitals, the medical care centers, and so forth. And then transitional elements. So where organizations, for example, already have an authorization with a third party or a business associate, and they're looking to move to a different associate, and the effect that has on handling of PHI data in between contracts or in between authorizations or transition between multiple authorizations. So in a similar way to security, it sets three key subject areas with multiple sort of sub-clauses, sub-requirements for an organization. And I guess the first... Sorry, go ahead, Sophie.
No, go on, Thomas, you carry on, because you might already ask some more questions.
All I was going to say is, why is this important from a third-party perspective? So both the security rule and the privacy rule, all of those areas are required by a third-party organization where appropriate. So this is not all just information security rules, controls, policies, and processes that say a healthcare organization needs to implement themselves, but where they're using third parties and those third parties have access to the same type of data, the same security and the privacy rules apply. And what we'll see in a short moment is how we can use this and use the concept of the business associate agreements and contracts to identify that and to incorporate them across formal agreements and terms of service. Sophie.
Yeah, great, thank you. And you slightly touched on this before, so you've gone through kind of the security and privacy rules in terms of those areas and what HIPAA stipulates is in terms of these are the things that we need to measure and be aware of. Are there any stipulations, and we see this in TPRM in general, right? Mm-hmm. We have different criticalities of vendors that could be measured in different ways depending on the standards and frameworks and regulations you're adhering to.
Yes.
Is HIPAA similar in that way, in the sense of we've got these rules for security and privacy? Do they then waver based on the criticality or what type of data or the extent of the data that they have access to?
Yes, I'm going to say yes and no. I know that's quite difficult. That's being difficult, but this is actually something that's typical. We find in actually a lot of regulations now where they're setting clear enforcement. So you need to drive privacy and security controls. If you've got a third party who's handling this type of data, you need to enforce those controls as well. But where I say it depends is also because in many ways, it's up to the organization. And there's an expectation that obviously we need to demonstrate we apply the security and the privacy rules, and expectations, and we're doing the same to the third party. But we need to have awareness of that third party, and depending on what they do, they may need every control, every requirement, or a subset or a smaller volume of requirements. And so although it doesn't specifically state, say from a tiering perspective, tier 1, tier 2, tier 3, or critical, medium, low type of organizations, it's very much up to that business to determine and ultimately demonstrate, of course, to the regulator, these are the controls that we're enforcing through our third party and maybe subsequent fourth parties. And these are the business justifications why. I guess ultimately it'll then come to a discussion between your regulator and organization if HIPAA feel that actually there are other controls that should be in place, and say a data breach is as a result of not having those controls in place, and that's the sort of discussion that may warrant the decision point around, do we need to issue a violation order or penalty? But ultimately, yes, HIPAA makes it clear when a business associate needs to be involved or a type of control, but it's then up to the organization to determine based on their process and their methodology, as long as they can then demonstrate it to the auditor, to the regulator. Yes.
So having all of that information and kind of collated, centralized, and all of those attributes that are relevant to making those decisions needs to be recorded to enable an organization to effectively deliver back to an auditor.
Absolutely, yeah, and that's the best way to look at it as well. If an auditor came by tomorrow or next week and said, I want you to show me how you comply to these regulations or how your third parties comply, how will you demonstrate that? Is it through forms and reports and documentation? Is it through systems to track and manage third parties? Is it a combination of both to say, we've done our due diligence, here are the risks based on our third parties, and here's how we're managing those risks. So yes, it's always worth thinking about what method or series of methods you want to use and apply.
Brilliant. Thank you.
So let's move on to, again, another key term. So you touched on PHI. Another one that keeps cropping up is business associate. And as I mentioned, particularly around the security rule, but both security and privacy rules, this term keeps on repeating itself. So covered entities and business associates should do X, should do Y, should do Z. So what does a business associate mean? Person or organization other than a member of a covered entity's workforce that performs certain functions or activities on behalf of or provides certain services to a covered entity that involves the use or disclosure of individually identifiable health information. I'm giving a lot of tongue twisters today in this webinar, I've noticed. Bit of a mouthful. Let's again try and break that down. Essentially what it's saying is business associates can include any third-party organization who accesses or manages PHI based on the way HIPAA have identified individually identifiable information, as you've seen earlier. And it then also gives a breakdown of a range of different businesses. I've got 3 up on the screen now. So third-party administrators, for example, administrators who maybe help with claims processing for health plan, consultants and consultancy firms that perform utilization reviews for a hospital and carries out formal reviews, legal organizations, attorneys who provide a legal service, which may mean accessing a health plan and accessing protected health information. And this is an example of 3 different types of organization that could all fall under the banner of a business associate. And one of the key areas to highlight here is the HIPAA Security Rule requires organizations or business associates to develop frameworks for risk assessments and implementing controls that address the result of those risk assessments. So again, thinking back to sort of that top level of, have you identified the risks associated of how you're handling PHI and health information and health data? And have you set a series of controls to manage, to mitigate, to treat those risks and to address those risks and those concerns? So generally, we could say it's any business association that's involved in claims processing, data analysis, quality assurance, billing, practice management, anything that involves that PHI or that identifiable health information. So quite a few different types of organizations, and the HIPAA website goes through a much more extensive list of all the type of businesses that do apply.
Thomas,
go ahead.
I was going to say, we're talking through kind of business associate PHI. We have a question in the Q&A, which I think could be quite relevant to the conversation now. So just wanted to call it out.
Sure.
The question is, do you believe a privacy officer's only concern is PHI protection, or should they be responsible for reviewing and risk rating all offshore data due diligence as well? If not, which department, according to industry standards, does this responsibility fall under? I can break that down too as well. If that's
yes.
easier.
So when it comes to privacy and privacy office, obviously, yes, their focus should be on how PHI data is being used. Certainly from an offshore perspective and where that data is being sort of handled, is being sort of handled, dealt with, manipulated, used, stored in whichever capacity. I would say yes, a privacy office should have oversight of that. They should have a level of review of making sure that data, because ultimately, obviously, what we need to think about is the data and who's responsible for that data and managing that data. I think in GDPR talk they call it sort of data owners and data processors. In terms of who has responsibility and accountability for that. But at the same time, I guess this is a good example of if you have data that is split across multiple countries or is going across multiple geographies based on the type of supplier and third-party organization that's using it or handling it, there could be a need to involve other functions and departments. So from a legal perspective, so if there's a governance risk and compliance function, if there's obviously a legal office or legal side of the business, which more often than not there is, I think it's very important to get them involved as well. But yes, ultimate oversight on, is that data being handled in a secure and appropriate manner? It's definitely one from a privacy office area.
Perfect.
I hope that's good. Okay. I mentioned throughout, and certainly earlier today, this is obviously the term of business associates, which we've identified, but also associate contracts as well, or associate agreements. So HIPAA also requires that a covered entity includes certain protections for the information in a business associate agreement. If you think about ISO 27001 and NIST, this would be around the supply chain risk management control areas, where we're saying you're engaging with a third party, they're holding sensitive information. Have you done your due diligence around what controls they should be implementing and should be enforcing? So number one is obviously the agreement to comply with those HIPAA rules. And we've just seen through today that there's a lot of, I say, repetition in saying those words. A business associate shall do X, Y, or Z based on the control. And so first off, if we know that they fit under the banner of individually identifiable health information, that yes, they do need to comply with the HIPAA rules as dictated by the security and privacy rules. Implementation of security standards for safeguarding PHI. So thinking back to the security rule, we have those three areas. So technical controls, physical controls, and governance-based controls. So everything from risk management to security awareness and training to business continuity, data security and encryption controls, backup, and so on and so forth. And so this is where organizations should then think about what are the most appropriate controls that we need to enforce and capture within that agreement, and that we need that third party to sign up to. And this is where it becomes quite interesting in terms of, should we capture everything and that's identified within the security rule? No. It very much is dependent on the type of service. There may be conditions, for example, where the physical controls, the physical security controls are not as critical. More often than not, the governance and technical controls will be critical because we're still talking about personal PII. But if, for example, this third party is coming onto your site rather than storing data in their premises, in their operations, then maybe some of the physical security controls are less of a concern because they're managed by yourselves. But certainly thinking about what controls should best fit this third party is a key area to consider. Notification of breaches is very important. I'm coming onto this as part of the violation piece shortly. But setting a clear, agreed form or type of communication such that if a breach does occur from a third party's premises or operations, how are they going to inform you? So you can then inform the appropriate authorities as well. So thinking about how is that communication going to be built? Should a data breach or an incident should occur within that third party? And then extendable clauses to subcontractors, or what we might call fourth parties. And so it's important to highlight this as well. So in many cases, we may be dealing with one third party and information doesn't go beyond them. Makes it a lot easier in terms of the management and communication and obviously oversight of security and privacy controls. But obviously, as we know, in some cases, and thinking back to the map we saw earlier on, the ever-expanding supply chain, particularly as new applications and systems come in. So thinking about, well, how do you extend those same clauses that you're asking a third party to adopt to their third parties, your fourth parties as well? And so it may be appropriate to say, where you are using a third party, where there is obvious knowledge that their third party has access to the same health information, that we also require you to have certain due diligence processes in place, for example, around the access to that data, the training of staff, the background security checks, whatever's appropriate based on the product and service. And of course, this brings us on to that importance of knowing the profiling and tiering of your third parties, and if appropriate, your fourth parties as well. Obviously, the more we know, the more easier it will be to identify and determine what type of controls are being used, or should we be asked to be enforced as well. So we have our controls. We have our business associate contracts. We've established contracts with a third party. We've signed the contract, delivering a product and service to us. They're handling health information. We've set a series of controls that they should be following, from managing access and privileged access, for example, to those systems, to managing a business continuity program so they can recover from disasters in a timely fashion. However, HIPAA also set out quite clearly rules on what's considered as a violation. And failure to enforce or abide by the security and the privacy requirements can result in minor to severe penalties, particularly where the impact from a loss or lack of protection of PHI, a loss of confidentiality, integrity, or availability is significant. And so on the left-hand side, we can see what HIPAA term as a violation. So where a HIPAA-covered entity or business associate fails to comply with one or more provisions of the HIPAA privacy, security, or breach notification rules, an impermissible use or disclosure under the privacy rule that compromises the security or privacy of the protected health information. What does this mean in practice? So we could be looking at, I mentioned use and disclosure previously, unauthorized use and disclosure, unauthorized access of PHI. So before, we mentioned in the privacy section, it says that what is deemed permitted use and disclosure, and one of the areas that's not permitted is the sale of health information. So certainly if an organization, if a third party then proceeds to sell health information, unwittingly or deliberately, to advertising, marketing agencies, or other type of organizations, that could be considered a breach and a violation. Failure to provide patients access to their own PHI. What's interesting about that particular, where that sits under the list of violations, is it's found to be one of the most common violations so far. It's where patients have for one reason or another requested or tried to gain access, and they've not been provided access to their own health information. Failure to conduct regular risk assessments to make sure that you are meeting the privacy, security rules and requirements, even improper disposal of health information. So there's quite a few different areas that could be classified as a violation. Usually these can be found and picked up through audits, external audits, internal audits, maybe internal supervisors, if they spot an individual who's violating a particular rule. If you have obviously a privacy office whose responsibility is to make sure that compliance is in place. And what can this lead to? There's a few different penalties, actions, non-conformities, if you will. As you can see, monetary penalties, that's a particular common one, ranging from $100 to 50,000, depending on the type and the severity of the penalty, whether it's a deliberate breach, whether it was an accidental breach, and what level of PHI was, say, disclosed, disposed, or breached the level of confidentiality or integrity of that information. So there's obviously various means and processes that HIPAA goes through, and the OCR, the Office for Civil Rights, who are responsible for issuing those fines, those sort of violation reports, and enforcing the action. In some cases, it could be criminal penalties if there's a deliberate breach of privacy and security provisions. And in some cases, corrective action plans, or what we sometimes call CAPAs, corrective action, preventive action. So clear processes and plans to correct and prevent any further violation or breach of compliance. So, for example, where it's found that a particular control has not been implemented, it's not been enforced, and through that there's maybe negligence of poor security controls in place, there may be a need for the OCR to issue a clear corrective action plan and expect an organisation to implement and develop that plan so that those areas can be filled, those gaps can be filled. So that penalty very much depends on the nature of the violation, the severity, how much harm is caused, and the level of efforts that are made to mitigate the breach. And this obviously brings us on to some of the level of communication that organisations and business associates need to provide to the regulatory bodies as well. And it may be through that communication, if a violation has been committed, but an organisation has already taken proactive steps to correct the issue, correct the gap, implement formal processes to from an incident management perspective to recover data, whatever the process is. Again, all of these actions will help determine what type of penalty the OCR issues. And as you can see lastly at the bottom there, so the OCR, so again, the Office for Civil Rights is expected to continue to aggressively enforce HIPAA compliance in 23 after a record-breaking year of HIPAA fines and settlements. As I say, many of them from what we've seen involve failure to provide patients access to their own PHI rather than some of the more severe cases, as I said, so deliberate selling of health information, for example.
Thomas, just on the, it's interesting to see some of the impacts on a violation there.
Yes.
Organisation standpoint, are there any, I guess, recommendations on frequency of reviews of some of these rules that they have in place? So in terms of re-reviewing it, just to ensure that you can have as many of those actions in place or prepared in case of a violation that would support an organisation?
Yes. So in multiple security and privacy controls, HIPAA do make it clear that there needs to be a level of review, whether it's, for example, reviewing sort of business continuity, disaster recovery plans, and testing those plans and capabilities, for example, to the way they conduct audits, the way they review their risks and the risk cycle, for example. What they don't do at that stage is obviously dictate in terms of it must be reviewed every month, every 6 weeks, every year. Again, I would say they leave it to the organizations, but then again, it's also about being reasonable as well. What you'll often find with these type of areas, such as take the continuity aspect, for example, around can we recover from a environmental threat, for example. Best practice says you should conduct tests at least annually. If you can afford to do more throughout the year, then even better. In some cases, you may have to do more if you're dealing with highly sensitive systems or you're in a geographic area that's deemed highly sensitive, whether geopolitically or environmentally, for example. And so there's multiple instances where organizations should have a formal review, which again translates to third parties. So we've asked third parties through the agreement, are they implementing these controls? Let's think about that due diligence. So performance reviews, on-site or remote audits of our third parties, and other areas that are appropriate. So yes, there are multiple occasions where organizations should, if they're doing it properly, have a chance to review these practices. But then again, obviously we can never predict also what's happening, and there will always be sort of threats and vulnerabilities that come in. But yes, certainly those reviews should go towards the wider mitigation and own sort of awareness piece.
Yeah,
absolutely. The company should focus on.
That's great, thank you. And I think similar, well, kind of on this topic as well, we've actually had a question in the Q&A around fines. So one of the questions is, are OCR fines able to be fought as being perceived as excessive?
Yes. So OCR, as I say, they're responsible for saying this is worth $50,000, or let's take the two extremes. This is worth $100 worth of fine, or sorry, we can issue not this worth. We can issue $100. We can issue $50,000 fine. Obviously, they do their own due diligence first, but there's always going to be the capability to appeal. I guess generally that's going to come down to if an organization feels that, yes, we may have breached a security or privacy area, but based on what we've done, based on how we've handled it, for example, based on the fact that, let's say, for example, PHI has not been leaked out or has not been removed, and so the impact is low, we believe we've done enough to actually warrant a lesser penalty, if you will, or violation. But obviously the OCR do and are responsible for looking at the wider picture as well. And that's where things like these corrective action plans can come in place to say, actually, you've got good practice in place. You do need to look at implementing these areas, or you should be implementing these areas, sorry, to prevent further breaches.
Brilliant. Thank you.
So I mentioned notifications of violation. So where issues do occur, organizations should have a clear plan to report violations. And HIPAA highlight the timeliness of a notification, what should be notified, so the details, so the descriptions of a breach, when it was discovered, type of PHI that was involved in the breach, and who to, whether it's notifying the individual whose data it belongs to, the media, if it's a notable case, the secretary of the OCR and HHS, so the Office of Civil Rights. And so there's various processes to notify different individuals. What's interesting about this one, if you look at the top under timeline, is without unreasonable delay and in no case later than 60 calendar days after discovery of the breach. That's really interesting, particularly when you compare it to other privacy regulations and requirements. GDPR, for example, I believe requires no more than 48 hours, if I'm not mistaken, 48 or 72 hours to the relevant data privacy regulator. CPRA in California and CCPA have something similar. 60 days, personally, seems quite a long time. I guess in many ways that gives an organization sufficient time to not only identify what the root cause is, but put in place actions and plans of attack in terms of how we will or how we have addressed it as well. But as you can see, it's quite a large time frame, and that extends to third parties as well, or business associates. So business associates, as we've mentioned, as part of the agreement, must provide notice to an organization upon the discovery of a breach. But that also means they can provide that notification of a breach up to and no later than 60 calendar days of the discovery. Now, if you want to reduce that and particularly within the terms of agreement with a third party business associate, because 60 days, 2 months seems quite a long timeline without knowing that 60 days ago a breach happened. We're only just being told now. Formally, from a HIPAA requirement, that's the expectation. However, if there's an agreement between yourself and the third party for a more reasonable timeline, that's something that would be captured within the business associate agreement. But formally, from a HIPAA perspective, no later than 60 calendar days after discovery of a breach. And you'd hope also within that time frame, depending on the type of breach, there's been enough thought and process to work out an action plan, let's say, or plan of attack as well. So, thinking about the wider TPRM capabilities and sort of how this can be addressed from a PHI risk perspective. So establishing a structured TPRM program or risk management framework certainly can help ensure that not only PHI risks are being identified, we have that process to review, monitor, and address those risks as well. So from preparing and developing a risk plan and understanding where is our health information created, where is it being received and maintained, what data processing do we do, what data transmission Do we have data flow processes and data flow diagrams that can demonstrate and that can give us visibility of where this data is being held and managed? Because obviously, the greater visibility we have of what we're doing with that data, the greater we can work out what areas are posing the greater threats. What threats and vulnerabilities should we be concerned about, whether it's natural, human, environmental-based threats, cyber-based threats, ransomware. We mentioned at the start the use of aged systems, redundant systems, or sort of old, out-of-date systems that are no longer patched, for example, and supported. So there's a lot of areas, obviously, to think about, but we should always have in the back of the mind the relationship to the PHI itself and where it's being stored. And again, to borrow the ISO phrase, the confidentiality, integrity, and availability of that data as well. Obviously, if thinking of the traditional format of risk management, from identifying the threats and vulnerabilities, looking at, well, how do we quantify this? So is there a risk likelihood of occurrence? What's the level of impact it will have to PHI, to the owners, custodians of the PHI data, to the individuals whose the data it relates to? So starting to think about, well, how do we quantify how likely that threat will occur? And if it has occurred, what level of impact is it going to be to protecting that health information? And of course, all of this should then help build up that picture of the type of controls and best practices that we need to implement. Obviously, once you've got a likelihood and impact, combining them together to say what's the overall level of risk to EPHI as a whole, to electronic protective health information, but also non-electronic health. I should make that clear, sorry. But what's the overall level of risk to the health information? So we've identified a formal risk process. We've got the PHI at the back of our mind, and there's the expectation from a third-party perspective that they've done the same because we're handling them that type of data. So what's the level of risk that we need to be concerned about? And then finally, making sure we've got a process to record, risk review, and plan for any remediation to deal with those risks and to implement the necessary controls. Application controls required to protect PHI and to create, receive, maintain, or transmit electronic and non-electronic protected health information. As I say, it's a fundamental aspect of third-party agreements or BA agreements. And the rule requires organizations to develop that framework for risk assessments and implementing controls that address the results of those risk assessments. So what does this mean in practice? Well, it means obviously identifying risks associated with that health information. Have we identified what are those minimum controls? And again, thinking about the type of vendors, the type of organizations we're dealing with, that can also have an effect on identifying, do we need to enforce physical security controls, for example, based on what they're doing with the data? Are there particular aspects on the use and disclosure of information that, again, we need to enforce, or we need the third party to demonstrate that they're implementing? And finally, establishing that ongoing process for monitoring and adjusting security and privacy controls as and when new technologies emerge, new and emerging threats, and of course, changes to the regulations as they do on a periodic basis. And what all this means is it's all wrapped under that consistent risk process, having that structured approach for identifying and managing risk, using some form of third-party risk process and program, and having that consistency and continual review process to enable a recurring third-party assessment. So year on year monitoring of risk, adapting to new and emerging risk, and ensuring those security and privacy controls that we're asking our business associates, third parties to implement are being effective or effectively conducted. So in summary, what does this mean, or where do we go from here? So obviously, if we haven't already, started to develop the HIPAA third-party risk assessment process. So we start to understand where HIPAA requirements are necessary for business associates, start to understand those security and privacy elements that we need to enforce on the third party. What's expected that a BA should be demonstrating when handling health information? And what do we start to incorporate into a formal contract and agreement? Once we've done that, we start to build our critical control domains, mandatory control requirements, standards mapping within HIPAA to identify those critical controls. And then that process of engaging those third parties, conducting those regular risk assessments, and executing plans to address the risk, so that if we need to demonstrate compliance, if we need to demonstrate compliance to HIPAA, security and privacy rules, we've got that process to say, we've done our due diligence for our third parties, and we're going through that regular process and continued improvement process. I'd now like to very briefly hand over to Scott.
Thanks, Thomas. Awesome, everybody. Real quick, 10-second overview. If you're challenged with assessing your business associates against the security rule or the privacy rule, we've got built-in assessment content in the Prevalent platform to help you automate that process, enable workflow to help you progress that assessment through its life cycle, gather some external intelligence to validate that those controls are in place, and give you good risk reporting to determine where your riskiest business associates are and the remediation recommendations to then reduce that risk over time. We also have what you see on the screen right now, which is our HIPAA third-party risk management checklist, which is a 10-page guide that really breaks down the security rule in very finite detail, and then provides some best practice recommendations and capabilities to help make that process faster. I'll pitch it back to Melissa. You guys can open up for questions.
Oh, there we go. Since we are at the top of the hour, I'm going to go ahead and drop my email in the chat real quick. So if there is a question, I know a lot of people have to drop for meetings if they haven't already, but let's see, prevalent.net. There we go. Can't talk and type at the same time. But, I really do appreciate Sophie and Thomas. Obviously, your brain is so fun to pick. And Scott, thanks for doing a very expedited spiel on how Prevalent can help. But you will get a copy of this in your inbox shortly. And like I said, my email's in the chat if you need it. And that is pretty much that. I hope you guys have a great rest of your day or evening, wherever you are. And we will see you hopefully at a future webinar.